Welcome to your Europatent Brief Journey with Barış Atalay. We start our EQE D1 journey with the year 2024.
Question 1.
International Application PCT3. On 5 January 2024, applicant D filed International Application PCT3 at the Spanish Patent and Trademark Office, acting as the receiving office. The PCT request designates the EPO as the International Searching Authority. The filing fee, search fee, and transmittal fee were all duly paid. On 17 January 2024, the SPTO sent a notification inviting applicant D to furnish a translation. Now let's tackle the questions step by step. A. In which language was PCT3 filed, and what steps does applicant D have to take for the ISA to start the search? Let's break this down. Language of filing. PCT3 was most likely filed in Spanish, as it is the only language accepted by the SPTO as a receiving office. If the application had been in another language, the SPTO would have transmitted it to the International Bureau instead. Steps for ISA. Search to start. A translation of PCT3 into English or French must be submitted to the SPTO. This is because the EPO as ISA only conducts searches in these languages. The deadline for the translation is set by the SPTO in the notification, typically 2 months from 17 January 2024. Reflection moment. What happens if applicant D misses this translation deadline? Exactly. Late filing of the translation is still possible, provided the required surcharge fee is paid within the applicable time limits. B. Amended claims and rectified description. Applicant D wants to file amended claims and correct an obvious mistake in the description at the lowest possible cost. Here's what you need to know. Amended claims. Where to file? With the International Bureau under Article 19 PCT. When to file? After receiving the International Search Report, but before the end of the 16th month from the priority date. Language? In the language of translation, English or French. Rectified description? Where to file? With the EPO as ISA under Rule 91 PCT. When to file? As soon as possible after the mistake is noticed to avoid delays. Language? Both in the language of the original application, Spanish, and in the language of translation, English or French. Reflection moment. Why is the rectified description filed in 2 languages? Correct. The EPO as ISA must compare the rectification with the original to verify its accuracy. Common mistakes. Let's take a moment to highlight areas where it is possible to lose points. Filing language. It is possible to wrongly assume that PCT3 could be filed in languages other than Spanish at the SPTO. Translation deadline. Also possible to miss the chance of late filing with a surcharge. Amended claims language. It can be incorrectly assumed that they must be filed in the language of the original application rather than the language of translation. Rectified description. One should not forget that it needs to be filed in both the original language and the language of translation. Recap and reflection. Up to this point, we covered the language requirements for filing and translation under the PCT, the steps required to initiate an ISA search, how to handle amended claims and rectified descriptions, ensuring compliance with both language and filing requirements. Take a deep breath, reflect on the process, and practice managing these details for your exam.
Question 2.
In November 2021, Company C filed European Patent Application EP2. Only the filing fee and search fee were paid. The publication of the European Search Report, which included a negative search opinion, was mentioned in the European Patent Bulletin of 17 May 2023. On 26 May 2023, the EPO issued a communication pursuant to Rule 69 EPC and an invitation pursuant to Rule 70 A1 EPC. However, no further actions were taken by Company C. Due to an isolated mistake in an otherwise satisfactory monitoring system, Company C became aware only today of a communication from the EPO, dated 12th of December 2023, notifying a loss of rights. The question is it still possible for Company C to prosecute EP2? If so, what steps must be taken and by when? Now we'll explore a common EQE scenario with missed deadlines and their consequences under the EPC. This topic may seem overwhelming at first, but don't worry. I'm here to guide you step by step. Let's start by understanding the situation. Imagine an application where 3 critical acts were missed. The examination fee wasn't paid, a reply to the written opinion wasn't filed, and the designation fee was overlooked. Here's the key point. Each of these omissions leads to the application being deemed withdrawn independently. That's right, independently. But it is possible to forget this crucial detail and fail to cite all the relevant legal bases for these omissions. Next, let's talk about the remedies. We should correctly recognize that further processing is an option. However, the time limit for further processing had already passed, leaving only re-establishment of rights as the remaining solution. Now here's where mistakes often occur. It is possible to miscalculate the 1-year time limit for re-establishment under Rule 136(1) EPC. Reflection moment. Can you recall where this time limit starts? That's right. The calculation begins from the missed time limit for further processing, not the date of the omitted act. Keep this distinction in mind. It's vital for scoring full points. Let's now look at the list of required actions. When applying for re-establishment, you must file the request, pay the fees for further processing, the examination fee, and the designation fee. One final but critical detail often overlooked is the renewal fees. It is important to note that third-year renewal fees will become due on the notification date of the decision re-establishing rights. Recap and reflection. So far, we've covered the following: omitted acts, examination fee, designation fee, and reply to the written opinion. Independent withdrawal. Each omission triggers withdrawal independently. Missed further processing deadlines. Re-establishment becomes the only remedy. Time limit calculations. Always start the 1-year time limit from the missed further processing deadline. Required acts and renewal fees. File all missing acts, cite the legal basis, and don't forget renewal fees for the 3rd year. Take a deep breath. Reflect on what we've discussed. This is a challenging topic, but with consistent review and practice, you're mastering the nuances of the EPC step by step.
Question 3.
Scenario recap. The opposition period for EP1 expired yesterday. On 16 January 2024, A and B, both nationals of Spain, jointly filed a notice of opposition against European Patent 1. A resides in Mexico, and B resides in Spain. The opposition fee was paid on the same day. The notice was filed in Spanish, included all required particulars, and was signed by both opponents. However, on 29 January 2024, the Opposition Division issued an invitation to remedy deficiencies, giving a 2-month deadline to comply. Yesterday, B filed an English translation of the Notice of Opposition. Question: what procedural steps must be taken for substantive examination of the joint opposition to start? Step 1. Invalid signature of A. The first issue lies in the signature of A. In a joint opposition, each opponent or their duly authorized representative must sign the Notice of Opposition. Since A is not resident in a contracting state, A must appoint a professional representative under Article 133(2) EPC. Step 2. Deadline for remedying deficiencies. The invitation of the Opposition Division is an invitation under Rule 77(2) EPC. A must appoint a professional representative by the deadline. Arrange for the signature or approval of the Notice of Opposition by the appointed representative. Let's calculate the deadline. The invitation was issued on 29 January 2024 with a 2-month time limit. The deadline is 29 March 2024. But since this falls on Good Friday, the deadline extends to 2nd April 2024, Tuesday, under Rule 134(1) EPC. Reflection moment. What happens if A fails to appoint a representative by this date? Exactly. If no representative is appointed, A's participation in the opposition will lapse. Step 3. Filing of the translation. The notice of opposition was filed in Spanish, which is acceptable under Article 14.4 EPC, as both A and B are Spanish nationals. However, a translation into an official EPO language, English, French, or German, was required and had to be filed by the expiration of the opposition period. Let's confirm the timing. The translation was filed yesterday, which was the last day of the opposition period. Therefore, it was filed on time under Rule 6.2 EPC. Step 4. Deficiency in the translation submission. The translation was accompanied by a letter filed by B, but this letter is not signed by the common representative, since A's representative has not yet been appointed. Under Rule 50.3 EPC, in combination with Rule 86 EPC, the letter will be considered not duly signed. What happens next? Once A appoints a professional representative, this representative will also be deemed the common representative under Rule 151.1 EPC. The EPO will invite the common representative to sign a letter accompanying the translation within a specified time limit. Once signed, the translation will retain its original filing date and be considered filed in due time. Recap and reflection. To summarize, here are the procedural steps required. A must appoint a professional representative by the 2nd of April 2024 and arrange for the notice of opposition to be signed or approved by the representative. The common representative must sign the letter accompanying the translation when invited by the EPO. Key points to remember. The translation filed by B retains its original filing date once signed by the common representative. The professional representative for A automatically becomes the common representative upon appointment. Take a deep breath and reflect on this process. Joint oppositions require precise handling of procedural rules. Missing a step, such as appointing a representative or signing documents, can result in loss of rights.
Question 4.
Scenario recap. Your client, Company E, is the proprietor of granted patent EP4, which contains Claim 1, independent claim directed to subject matter A. Claim 2, dependent claim directed to A plus B. Claim 3, dependent claim directed to A plus C. Claim 4, independent claim directed to subject matter D. Company F filed an admissible opposition against only Claim 1, citing a lack of novelty in view of EPD1. However, after receiving a summons to oral proceedings, Company F introduced 2 new prior art documents. EPD2 discloses subject matter A. EPD3 discloses subject matter D. Let's analyze how Company E can secure a valid patent with the maximum possible scope of protection. Step 1. Late filed evidence. Admissibility. Key question: will EPD2 and EPD3 be admitted into the proceedings? Under Article 114.2 EPC and Guidelines E6 2.1, the EPO may disregard evidence that is late filed, i.e. submitted after the opposition period has expired. Article 99.1 EPC, Rule 76.2 C EPC. EPD2, this document is prima facie relevant to the novelty of Claim 1. It will likely be admitted into proceedings under Article 114.1 EPC. EPD3. This document relates to Claim 4, which is outside the extent of the opposition. It will not be admitted following G991. Step 2. Impact of EPD2 on claim. With EPD2 admitted, Claim 1 lacks novelty under Article 100A EPC in conjunction with Articles 52.1 and 54.3 EPC. Reflection moment. What options does Company E have to salvage the patent? Company E should amend the claims by filing a new main request, including Claim 1, directed to A plus B from Dependent Claim 2. Claim 2, directed to A plus C from Dependent Claim 3. Claim 3, directed to D, independent. This replacement of one independent claim with 2 independent claims is admissible under Guidelines H2 3.1, as it is occasioned by a ground for opposition. Step 3. Validity of the amended patent. The amended claims will remain novel over EPD2, as neither A plus B nor A plus C are disclosed in the prior art. Be maintained in amended form under Article 101.3 A EPC. However, there's a problem with Claim 3, Subject Matter D. While Claim 3 lacks novelty over EPD3, this claim cannot be deleted during opposition because it is outside the extent of the opposition, as established by G991. Step 4. Post-opposition limitation. To obtain a valid patent, Company E must file a request for limitation under Article 105A(1) EPC after the opposition proceedings conclude. Key steps for limitation. File a new set of claims excluding Subject Matter D. Pay the limitation fee, Article 105A(1) EPC, Article 2(1) Item 10A rule fees. Once limited, the patent will cover only A plus B and A plus C, ensuring validity and the maximum possible scope of protection. Recap and reflection. Let's summarize the steps for Company E to secure the best outcome. During opposition, file amended claims directed to A plus B, A plus C, and D. These claims will survive the challenge from EPD2. Post-opposition, request limitation to delete Claim 3, which lacks novelty over European Patent D3. File the revised claims and pay the required fee to finalize the limitation. By following this strategy, Company E ensures that its patent remains valid and retains protection for the strongest subject matter. Take a deep breath and reflect on the process. This scenario highlights the importance of understanding the interplay between opposition proceedings, prior art, and limitation procedures under the EPC. With careful analysis and precise actions, Company E can preserve its valuable patent rights.
Question 5.
Scenario recap. Your client, applicant H, a national and resident of Morocco, filed European Patent Application EP7 in French in March 2020. The mention of the grant was published on 21st in February 2024. The key question is, what steps must applicant H take, and by when to, obtain patent protection in the UK and Poland? Obtain unitary patent protection? Part A. Patent protection in the United Kingdom and Poland. 1. Renewal fees. For Poland, the renewal fee for the 5th year is due within 2 months from the date of publication of the mention of the grant. 21st February 2024 plus 2 months equals 21st April 2024, Sunday. Since this falls on a Sunday, the deadline extends to 22nd April 2024, Monday, under Article 141(2) EPC. For the UK, the National Law Table 6 allows payment up to the last day of the 3rd month after the publication of the mention, 21st February 2024 plus 3 months, then 21st May 2024. Since the UK extends deadlines to the end of the calendar month, the due date is 31 May 2024, Friday. 2. Translation and validation requirements. Poland. The patent specification must be translated into Polish within 3 months of the publication of the mention of the grant. 21st February 2024 plus 3 months, then 21st May 2024, Tuesday, under Article 65(1) EPC. A special fee must be paid within 3 months from the invitation by the Polish Patent Office. Applicant H must also appoint a Polish national representative, as required by National Law Tables 4 and 6A. United Kingdom. The UK is a contracting state to the London Agreement. No validation acts, such as translations, are required for patents filed in French, as French is an official language of the EPO. Reflection moment. Can you recall why the UK does not require validation acts under the London Agreement? That's right. The UK has waived translation requirements for European patents filed in EPO official languages. Part B. Unitary patent protection. 1. Filing the request for unitary effect. The request for unitary effect must be filed with the EPO in French within 1 month of the mention of the grant. 21st February 2024 plus 1 month equals 21st March 2024, Thursday, under Rule 6(1) UPR. The request should include particulars of the proprietor, applicant H, the European patent number, particulars of a representative since H is a resident of Morocco, a non-EEA state, a full translation of the specification into English as required by Rule 6, 2. UPR. 2. Renewal fees. The renewal fee for the 5th year is due within 3 months of the notification of the communication of registration of the unitary effect. The exact deadline depends on the date of notification under Rule 71 UPR. The fee is payable directly to the EPO under Rule 13.1 UPR. Reflection moment. Why is a full translation required for unitary effect? Correct. Translations ensure transparency and accessibility during the transitional period for the unitary patent system. Recap and reflection. To summarize, here's what applicant H must do. A. Patent protection in the UK and Poland. Pay renewal fees. Poland, 22nd April 2024. UK, 31 May 2024. Translation and validation. Translate the patent specification into Polish by 21 May 2024. Appoint a Polish national representative. No validation required in the UK due to the London Agreement. B. Unitary patent protection. File a request for a unitary effect in French by 21st March 2024. Include a translation into English, along with the required particulars. Pay the renewal fee for the 5th year after notification of registration of the unitary effect. Take a deep breath and reflect on these procedural steps. By carefully tracking deadlines, renewal fees, and translation requirements, applicant H can secure comprehensive patent protection across multiple jurisdictions. With consistent practice, mastering these time limits and rules will become second nature. In our next session, we'll dive into another D1 paper. Until then, stay confident and keep practicing.